The Yolo County District Attorney's Office has had the Victim Services Program since the mid-1970s. At the very beginning, the Victim Services Program was more used as a program to be able to bring people to court when they had to testify. So when somebody was subpoenaed, the Victim Services Program would go out and bring those people back to court so that they would be able to testify in the hearings. In the early 1980s is when the program started evolving a little bit more to be what it is today, with the program being more victim-oriented and not so much prosecution-oriented. In order to receive services at the Yolo County Victim Services Program, the victimization must have happened in Yolo County, and the case must be being prosecuted through the Yolo County District Attorney's Office. Whenever a crime occurs in Yolo County, law enforcement is called out. When they're called out to the crime scene, they take a police report, they document what occurred, and then they send their police report to the District Attorney's Office. The District Attorney's Office then has one of the charging attorneys review that case. Once they decide what charges are going to be placed, then they go ahead and make the referral to the Victim Services Program. The Victim Services Program then picks up that case and calls the victim before the arraignment. The arraignment is the very first hearing where the defendant will be told what the charges against him are. A victim advocate will be assigned to the case as soon as the case is charged. If a case is not charged and they still want to receive victim services, they are able to call the Victim Services Program. We would be able to assist them with such things such as the California Victim Compensation application, as well as providing them with different resources in the community where they would be able to receive services from our nonprofit organization's community advocate programs. When a victim comes to the Victim Services Program, immigration status is not a criteria for them to receive services. The Yolo County Victim Services Program tries very hard to be very well-rounded. Our mission is to make sure that victims succeed in their role to become survivors. We do that by offering many different types of services and opportunities for victims to reach the survivor mode. Some of the things that we offer here in the Victim Services Program are programs such as the Violence Against Women, where we have an advocate that is solely dedicated to assisting victims of domestic violence and sexual assault. We also have our elder abuse advocates, which assist victims who are 60 years and older. On top of that, we also have an advocate that is dedicated to serving our victims going through the Restorative Justice Partnership Program. That is a program where defendants that have committed a crime are given an opportunity to resolve their case outside of the criminal justice system. We also have a program that we've recently started, which is the Hear Us Yolo. So what we're doing is we're putting together a coalition of survivors to be able to give that voice to victims so that the community leaders know what it is that victims need in Yolo County. There's always the question about what is the difference between community-based advocates and government-based advocates. Community-based advocates have confidentiality, where government-based advocates do not have confidentiality. What that basically means is that if a victim were to disclose something to the government advocates, which is the Yolo County Victim Services advocates, we have to turn that information over to law enforcement. Where if they go to a community-based advocate and they disclose the same information, they are encouraged to let the prosecution or law enforcement know, but they are not obligated to do so. Our goal as victim advocates is to be able to provide a voice, to provide eyes and ears for the victim in the courtroom. So we're able to let them know this is a time for you to be able to exercise certain rights as they come through in Marcy's law. Prosecuting attorneys also do not represent victims. They represent the state of California. But our goal as victim advocates is to make sure that that prosecutor understands the victim's stance. So the Victim Services Program is part of an association that exists throughout the state of California. Every single county throughout the state of California is required to have a Victim Services Program.
My specialty as a victim advocate is on cases that are affected by realignment legislation known as AB 109, which incorporates cases that are impacted by restorative justice. Victims can request notification of hearings, by informing their advocate that they wish to be informed of the arraignment hearing, the preliminary hearing, a trial readiness conference, a jury trial, any hearing that a victim wants to know about, an advocate will keep in contact with them about. If a victim wants to request notification of an individual being released from a jail or a prison, they would notify their victim of that issue, because the steps that an advocate needs to take to assist a victim with being informed of a release of an individual from a prison or a jail looks different county to county. So if a victim does wish to be notified of something, they must opt in to those services and to request those things. Restitution can be ordered in a criminal case once there is a conviction. And once a conviction has occurred, then the judge can order restitution that the victims are requesting. Victim advocates are a resource for victims who do wish to request restitution. We will assist them in outlining and itemizing all of their crime-related expenses that they can request through a criminal case. They can request restitution for anything that they wish to bring to the court's attention. What is not covered by criminal restitution through a criminal case is, except for in specific types of sexual assault cases.
Under Marcy's Law, victims have rights, especially to be heard in every hearing. My experience has been that the victim contacts me and they will inform me, hey, I want to make a statement. I want to address the court. I inform the DA that they will be there. The district attorney will inform the court to let them know that the victim's gonna address the court. So the victim could request to be present and address the court at every hearing. We inform the victims of every court hearing, especially bail hearings where possibly the defendant is going to be released, and have the right to address the court if they are opposed to the release and inform them why they're opposed to their release. If the victim does not want the defendant to hear the victim impact statement, they could certainly ask the judge to just read it, and they don't have to put it in the record. They could also request a protective order.
They can give this impact statement at arraignments when they first, when the defendant first gets arraigned, or at any time during the case. We give them an outline with it that asks, like, has this been affecting how you're sleeping? Your family members, how has this affected them? Basically how the case may be continuing, or since it happened, how it has affected them, anything that they want to share to the court. Victim impact statements are usually provided through an email that's read out loud, given to the advocate, or even the victim reading it out loud during the court. So when a victim gets assigned a victim advocate, we contact them and we let them know about the court process, how the case may proceed, because we never really know like how exactly it's going to go. And that's when we mention that if they ever want to go to court, would like to go to court, we would be accompanying them. So I let them know that I'd be there walking them through the process. For court support, if they are subpoenaed, which means that they have to go to court, we as victim advocates would be with them. I try to meet with them like 15 to 20 minutes prior court to go over even the layout of the courtroom of what would happen.
If somebody wanted more information on the Yolo County Victim Services Program, they can also go onto our website, which is yoloda.org, or give us a phone call. Our number is 530-666-8187.